I am delivering the lecture series relating to main topic of bringing on record of the suit, legal representatives of any deceased party in a suit or proceeding. So in said lecture series, so far I have delivered 7 part of my video lectures relating to various subtopics coming under this main topic. Now, the basic provision relating to this topic, it is contained under Order 22 of the Civil Procedure Code. So, in today's lecture also, I am discussing some other provisions coming under Order 22 of the Civil Procedure Code. Thus, the topic for today's lecture is substitution of third party as a defendant in the place of existing defendant or instead of existing defendant. For that, we have to consider the main provision contained under Order 22 Rule 10 of the Civil Procedure Code. But in this topic, we have also required to see the provision of Order 1 Rule 10 of the Civil Procedure Code and also the provision of Section 52 of the Transfer of Property Act. For discussing this topic, I am referring one judgment given by the Honorable Supreme Court of India. This judgment is reported in All India Reporter, year 2005, Supreme Court, page number 2209. This judgment is given by the Division Bench of the Supreme Court, consisting 2 Honorable Justices. The parties before the Supreme Court, this judgment is given in the civil appeal preferred before the Supreme Court. So parties before the Supreme Court are Amit Kumar Shah versus Farida Khatun and another. So here that Amit Kumar Shah is the appellant before the Supreme Court and that Farida Khatun and another are the respondents. In brief, the facts relating to this matter, that this appeal came before the Supreme Court from the High Court of Calcutta. There is one plot of land situated at important location coming under the limits of Municipal Corporation of Calcutta. So there is one plot of land and there is a dispute relating to that plot in this matter. That plot was owned by one Mr. Jagat Mohan Das, who is the original owner of that plot. That Jagat Mohan Das sold that plot to one Srimati Kalyani. So Srimati Kalyani purchased that plot. And when that Srimati Kalyani attempted to take under control the possession of that plot, then at that time one Mr. Fakir Muhammad resisted that attempt, because it was the contention of that Mr. Fakir Muhammad that said plot had been in his possession and enjoyment since many long years. But because that purchaser Srimati Kalyani attempted to recover the possession, therefore, said Mr. Fakir Muhammad, instituted one suit for declaration of his title, which is based upon the adverse possession. So, Mr. Fakir Muhammad instituted this suit for declaration and injunction before the trial court. So, he was claiming the title on the basis of adverse possession of that plot. In that suit, that original owner of that plot and the seller of that plot, Mr. Jagat Mohan Das, is the defendant number 1, and that Srimati Kalyani was the defendant number 2, purchaser. In the year 1989, trial court decreed the suit in favor of the plaintiff, Mr. Fakir Muhammad. That means trial court upheld his title on the basis of adverse possession. Being agreed by this order of the trial court, those both defendants preferred one appeal in the district court, that is lower appellate court. That lower appellate court, that is district court, allowed the appeal preferred by that Jagat Mohan Das and Srimati Kalyani in the year 1992. Accordingly, that district court, that is lower appellate court, in this appeal set aside the order and decree passed by that trial court in favor of Mr. Fakir Muhammad. So, because of the being agreed by this judgment and order passed by the first appellate court, that is district court, Mr. Fakir Muhammad preferred second appeal in the year 1993 before the High Court. Accordingly, Mr. Fakir Muhammad was the appellant and that Jagat Mohan Das and Srimati Kalyani were the respondent in said second appeal before the High Court. However, while that appeal proceeding was pending before the High Court, that respondent Srimati Kalyani executed one sale deed in the year 1995 in favor of Amit Kumar Shah. Accordingly, that Amit Kumar became the legal owner of that plot, and that Amit Kumar is here appellant before the Supreme Court in this present appeal, Amit Kumar Shah. Thus, that second appeal was prepared in the year 1993, and while that second appeal was proceeding of that second appeal was pending before the High Court, during the pendency of the proceeding, that Srimati Kalyani, who was the respondent before the High Court, sold that disputed plot to this Amit Kumar Shah. When, after purchase of that plot, when that Amit Kumar Shah made application to the municipal authority for mutation of his name on the record of municipality as owner, at that time, that municipal authorities told Amit Kumar Shah that some cases are pending in the courts relating to this property, therefore they are not able to update the mutation entry in favor of that Amit Kumar with respect to that disputed plot. Therefore, that Mr. Amit Kumar asked one advocate in the year 2002 to make some inquiry relating to pendency of that cases relating to that disputed plot. So after making inquiry by that advocate of Mr. Amit Kumar, he informed the Amit Kumar that there is appeal pending before the High Court. That appeal was preferred by one Mr. Fakir Muhammad and Farida Khatun, and it is a second appeal, and it is preferred in the year 1993. But that appellant in that appeal before the High Court never made any application for stay order during the pendency of that appeal, and therefore High Court has not so far passed any stay order against the order of that first appellate court, that is district court. So after making such an inquiry through the lawyer, Mr. Amit Kumar Shah, for the first time in the year 2003, got information that there is a pendency of one matter in the High Court relating to that plot which he has purchased in the year 1995 from that Srimati Kalyani. So until the year 2003, Mr. Amit Kumar was not having any knowledge regarding the pendency of matter in the court relating to that plot. Then after getting the knowledge, for the first time after getting the knowledge, Mr. Amit Kumar approached the High Court and he made one miscellaneous application before the High Court. In that application, he prayed to the High Court that he be made as a respondent in that pending appeal before the High Court in the place of original respondent Srimati Kalyani. So he made such an application for substitution as a respondent in the place of original respondent Srimati Kalyani. So it was the contention of the Mr. Amit Kumar for in his miscellaneous application, that original respondent in that appeal before the High Court has not having any present right, title or interest in said plot because she had already sold that plot to this Mr. Amit Kumar, and therefore now presently it is only the applicant Amit Kumar is having subsisting right, title, interest in that plot. Therefore, it is the contention of that applicant Amit Kumar before the High Court through this miscellaneous application that original respondent Srimati Kalyani will not contest effectively that appeal which has been preferred against her by that said Mr. Fakir Muhammad, and that appeal was against the judgment and order passed by the lower appellate court, district court. So it is a contention of that Amit Kumar that original respondent Srimati Kalyani will not contest that appeal because there is no need at all for her to contest that appeal because she has already sold that disputed plot to this Mr. Amit Kumar. So she is not having any interest in that litigation now. Therefore, it is a contention of that Mr. Amit Kumar that if suppose he has been not made as a respondent in that appeal before the High Court, and if suppose if the High Court did not hear him on merit, and if the High Court did not allow him to take defense before the High Court, and if the High Court passes the order in favor of the appellant Mr. Fakir Muhammad, then in that situation, said order of the High Court will be prejudicial to this applicant Amit Kumar because ultimately it is a huge loss to that Mr. Amit Kumar because he has purchased that plot, disputed plot. However, on 15 June 2004, by its order, High Court has rejected that miscellaneous application made by that Amit Kumar, meaning thereby High Court refused to allow Mr. Amit Kumar to become a party as a respondent in that pending appeal before the High Court. Therefore, against this order of the High Court, that Mr. Amit Kumar Shah has prepared this present appeal in the year 2005 before this Supreme Court, before the Supreme Court. So this is the present appeal. So when this matter came before the Supreme Court, Then firstly, the Supreme Court considered all related legal provisions relating to this matter. So which are those related legal provisions? First provision is Order 1 of Rule 10, that means Rule 10 of Order 1 of the Civil Procedure Code. Then Order 22 Rule 10, it means Rule 10 of that Order 22 of the Civil Procedure Code, and Section 52 of the Transfer of Property Act. Mr. Amit Kumar has made that miscellaneous application before the High Court for its substitution as a respondent in that pending appeal before the High Court under the provision of Order 1 Rule 10 as well as under the provision of Order 22 Rule 10 of the Civil Procedure Code. So let's see what are those provisions. First see Order 1 Rule 10. But for our matter, present matter, Sub-Rule 2 of this Rule 10 of Order 1 is very important. Sub-Rule 2, what is the heading of Sub-Rule 2? Court may strike out or add parties. What it says? The court may at any stage of the proceeding. So may means it is a power given to the court and it can be exercised at any stage of the proceeding. Court may at any stage of the proceeding either upon or without the application of either party. That means court can exercise power under this Order 1 Rule 10 either upon any application made by any party or without any application, without any such application. The court may at any stage of the proceeding either upon or without the application of either party and on such terms as may appear to the court to be just. The court may order that the name of any party who is improperly joined in a suit, whether as a plaintiff or defendant, be struck out. The name of such party be struck out who is improperly joined. Besides, the court may order that the name of any such person who ought to have been joined whether as a plaintiff or defendant, or name of any such person whose presence before the court may be necessary in order to enable the court to adjudicate upon and settle all the questions involved in the suit. Presence of such person is necessary in order to enable the court to adjudicate effectually and completely upon all the questions involved in the suit. The name of such person be added as a party in such suit or proceeding. So this is the provision under Order 1 Rule 10. So it gives power to the court to add any such person whose presence is necessary in order to enable the court to adjudicate upon and settle all the questions involved in the matter. Then see the provision of Order 22 Rule 10. What is the heading? Rule 10 of Order 22. Procedure in case of assignment before final order in suit. Procedure in case of assignment. It says that in other cases, here it is said in other cases because this Order 22 makes substantial provision. Order 22 makes substantial provision regarding bringing on record of the suit or proceeding legal representative of deceased party. Deceased party in a suit or proceeding. So provision relating to effect of death of any party to the suit. There are many provisions relating to this matter under Order 22. Therefore, this Rule 10 of Order 22 says that in other cases, means cases other than those of the death of a party to the suit, in other cases. Thus, in other cases of an assignment, creation or devaluation of any interest during the pendency of suit. Assignment, devaluation of any interest during the pendency of suit. Then such suit may, by the leave of the court, By the leave of the court means after obtaining the permission from the court, that the suit may, by the leave of the court, be continued by the person upon whom such interest has been devolved, or against such person upon whom such interest has came or devolved. So, in other cases of an assignment, devolution of any interest during the pendency of suit, such suit may, by the leave of court, be continued by or against the person to or upon whom such interest has came or devolved. So this is the main provision concerning our present discussion. Order 22, Rule 10. So in our case also there is a assignment of ownership right. There is a devolution of ownership right. Ownership right with respect to suit property, that is plot. That plot, ownership right, there is an assignment or devolution of ownership right of that suit property, that is plot, during the pendency of that litigation, before the court, and that assignment is by the party to that litigation in favor of third party. So in such case, the third party upon whom that right has, in favor of whom there is assignment of right or devolution of right, that third party can be substituted in the litigation as a respondent or a defendant, and suit may be continued with the permission of the court against such a respondent also. So this is the important provision, Rule 10 of Order 22. Then we will see the provision, third provision of Section 52 of the Transfer of Property Act. Why we have to see this third provision? Why we have to see this provision of Section 52 of the Transfer of Property Act? Because while opposing that miscellaneous application made by that Amit Kumar, that opposite party, that is opponents in that miscellaneous application, for the purpose of opposing that application, they took help of this provision of Section 52 of the Transfer of Property Act. So what is Section 52 of the Transfer of Property Act? Its title is Transfer of Property Pending Suit Relating thereto. So suit relating to that property, and when suit is pending, that property is transferred. So Section 52 says, during the pendency in any court, during the pendency of any suit or proceeding, during the pendency of any suit which is not collusive, during the pendency of any suit in which any right to involve property is directly and specifically in question, then the property cannot be transferred by any particular suit so as to affect the right of any other party to that suit, right under any decree or order which may be made in that suit, except under the authority of the court. So I will explain this provision. This provision will come into picture when there is a transfer of property during the pendency of any suit. But that suit should not be collusive suit. If the suit is collusive, then this provision will not come into picture. So what is collusive suit? In case of collusive suit, there is a secret agreement between the plaintiff and defendant. Means in fact, they are not really fighting against each other, but that they are just pretending that they are fighting. So there is a sham fight between them. So actually there is a secret agreement between plaintiff and defendant to conduct such a suit proceeding before the court with a qualified intention to cause some damage to any third party. So when in such cases, such suit is called collusive suit. But this Section 52 will not come into picture when the suit is full issue. So what it says, during the pendency of any suit in which any right to immovable property is directly and specifically in question. So suit proceeding should be relating to immovable property. Immovable property means the issues which are involved in that suit proceeding should be directly and specifically relating to any immovable property. So this section 52 is relating to only immovable property like land and building. So during the pendency in any court of any suit, in which any right to immovable property is directly and specifically in question, then the property, that is suit property, cannot be transferred by any party to the suit. Who are the parties? Either plaintiff or defendant. That suit property cannot be transferred by any party to the suit so as to affect the right of any other party. That means one party cannot transfer the suit property having the consequences that it will prejudicially affect the right of any other party to that suit. Which right? Right which may be declared or confirmed by the decree or order, ultimately by the court. That right. So property cannot be transferred by any party to the suit so as to affect the right of any other party, right, under any decree or order which may be made in that suit. But there is one exception. Such property can be transferred under the authority of the court, means after taking the prior permission of the court. Then only such transfer is valid. Otherwise such transfer are invalid because such transfer get hit by prohibition contained under section 52 of this act, Transfer of Property Act. So after considering the relevant provision, we will see how this miscellaneous application was opposed. For that, before the High Court, for opposing that miscellaneous application preferred by Amit Kumar, the advocate who is appearing on behalf of that opponent, Mr. Fakir Muhammad, he made argument for opposing that miscellaneous application. So that advocate appearing on behalf of that opponent Fakir Muhammad before the High Court in that miscellaneous application, he submitted that a person is not to be added as a defendant merely because he or she will be incidentally affected by the judgment in that suit. So this is not the criteria for adding any person as a party in the suit. He said that, he contended that a person is not to be added as a defendant merely because he or she will be incidentally affected by the judgment given in that suit or proceeding. So what should be the criteria? According to him, the main consideration should be whether or not the presence of such person is necessary to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the suit. So this is the main test, as also it is laid down under the provision of Order 1 Rule 10, because it is also said that name of any such person can be added as a party in the suit whose presence before the court is necessary in order to enable the court to adjudicate upon and settle all the questions involved in the suit. And how to adjudicate? Effectually and completely. It was also submitted by that advocate appearing on behalf of the opponent, Mr. Fakir Muhammad, that in the suit for declaration of title, a transferee from the defendant, transferee, in our case, Mr. Amit Kumar is a transferee, and who was the defendant? Here, Dependent means this now litigation is pending before the High Court. So instead of dependent, we can say it is respondent. So transferring from the dependent pendant light. Pendant light means pending the litigation. So in suit for a declaration, a transferee from the dependent pendant light is neither necessary party nor a proper party, in as much as he will be bound by the decree in the suit. He will be bound by the decree in the suit in view of the principle laid down in section 52 of the Transfer of Property Act. So with the help of this provision of section 52, they are opposing, that opponent is opposing that application preferred by Amit Kumar. Under the section 52, there are two things. 52 of the Transfer of Property Act. Firstly, it declares that during the pendency of suit, any party to that suit cannot transfer the suit property to any third person. And if suppose, if that property is actually transferred to the third person by the party to the suit, by any party to the suit, then whatever ultimate order or decision of the court in that proceeding will be there, that order or decision will be also binding upon that third party, even though he is not a party in that suit or proceeding. So here that advocate also said that in such a suit relating to declaration of title, a transferee from the dependent is neither necessary party nor a proper party, because ultimately he will be bound by the decree in the suit in view of the principle laid down in section 52 of the Transfer of Property Act. High Court has accepted this argument made by that advocate appearing on behalf of the opponent, Mr. Fakir Mohammed. So High Court, while disposing of this miscellaneous application made by that Mr. Amit Kumar Shah for his substitution as a respondent in that pending appeal before the High Court, the High Court, while disposing of this miscellaneous application, observed that the dispute in between the parties was in respect of a claim of title by of adverse possession. Therefore, this dispute have not any connection whatsoever with this present applicant Amit Kumar. So there is no connection of this dispute. The dispute is between that original owner, then its first buyer, and between that Mr. Fakir Mohammed, who is claiming to be in possession of that property and who is claiming the title on the basis of adverse possession. So for the adjudication of that particular dispute, the presence of this applicant Amit Kumar is not necessary before the court. Therefore, High Court observed that besides that, the applicant, this Amit Kumar, purchased the property during the pendency of appeal, and he has purchased the property in all probability with the knowledge of that pendency of the litigation before the court. Why there is a probability of the knowledge? Means it is an observation of the High Court that Mr. Amit Kumar must be having knowledge about this pendency of litigation relating to that plot which he has purchased. He must be having knowledge. Why? Because the litigation relating to that plot was going before the courts for more than 40 years. Moreover, High Court observed that being a purchaser, it is the duty of the applicant Amit Kumar to make proper inquiry before making purchase of that plot. And as per the section 52 of the Transfer of Property Act, that section 52 of the Transfer of Property Act has clearly prohibited the transfer of property which is the subject matter of the pending suit. So there is a provision under section 52. Therefore, the purchase in such case can only be done with the permission of the court. So High Court observed that admittedly no such permission has been obtained for selling that plot by the original respondent and for buying that plot by this Amit Kumar. No such permission was taken by the High Court, before whom that appeal proceeding of that appeal was pending. Therefore, this transfer in favor of the applicant is certainly hit by the doctrine of least pendants. Doctrine of least pendants as provided under section 52 of the Act. Doctrine means principle. That word least pendants, it is a Latin word. Least means litigation, pendants means pending before the court. So the rule which is contained under section 52 of the Transfer of Property Act, it is relating to this doctrine of least pendants. So I could observe that this transfer in favor of the applicant Amit Kumar certainly hit by the doctrine of least pendants. Therefore, now the applicant cannot claim at this stage that his interest is going to be affected unless he is made a party in this appeal proceeding. Therefore, I could observe that while rejecting the application of that Amit Kumar, that there is no merit in the present application, and as such the prayer of the applicant for adding them as a party in this appeal, this prayer is rejected. And because of rejection of that application by the High Court, that Mr. Amit Kumar shall prefer this present appeal before the Supreme Court against the order passed by the High Court. So, when this matter came before the Supreme Court, now this matter is before the Supreme Court, what is the observation of the Supreme Court? Supreme Court observed that in this appeal, present appeal, transferee pendent lit. Transferee means, for example, purchaser in our case, that Amit Kumar. Pendent lit means pending the litigation. That transferee or alignee pendent lit is bound by the final decree that may be passed in the suit. So, as per the principle contained under section 52 of the Transfer of Property Act. So, an alignee pendent lit is bound by the final decree that may be passed in the suit. Since because under the doctrine of least pendants, a decree passed in the suit, suit during the pendence of which transfer is made, such decree binds the transferee, because under the doctrine of least pendants, such decree binds the transferee, then in that case, his application by that transferee, application for bringing him on record of the proceeding, his application should ordinarily be allowed. So it is the observation of the Supreme Court. His application should ordinarily be allowed. And for that purpose, such transferee, for bringing himself on the record, for that purpose, he can make application under the provision of Order 22 Rule 10 as well as also under the provision of Order 1 Rule 10. So under both this provision of the Civil Procedure Code, Order 22 Rule 10, Order 1 Rule 10, such transferee can make an application before the court for adding himself or bringing himself on record in that pending litigation. Then High Court observed that, High Court, in this present appeal, Supreme Court also observed that as per the provision of Order 22 Rule 10, what it says, in case of assignment, devolution of any interest during the pendency of suit may by the leave of the court be continued by or against the person to or upon whom such interest has come or devolved. That means suit may be continued by the leave of the court. That means the concerned person, that is third party, who wishes to bring himself on record of that pending litigation, and for that purpose when he makes an application under order 22 rule 10, then he has to first obtain the permission of the court. Means he has to pray for the leave, grant of leave by the court. So here Supreme Court observed that under the order 22 rule 10, no detailed inquiry at the stage of granting such leave is contemplated. Inquiry regarding the validity of that devolution of interest. No detailed inquiry is necessary while granting such leave. Detailed inquiry by the court. The question about the existence or validity of such assignment or devolution can be considered at the final hearing of the proceeding, at the time of final hearing of the proceeding. So the court, while granting such leave, has only to be prima facie satisfied for exercising its discretion in granting leave for continuing the suit. That means for allowing him, that third party, to come on record as a party, prima facie satisfaction of the court is necessary. Only prima facie satisfaction. Then, regarding the provision of Order 1 Rule 10, it is the observation of the Supreme Court that the object of Order 1 Rule 10 is to save honest and bona fide claimant from being non-suited. That means any such third person may also have some strong claim with respect to any suit property, and therefore he wishes that he should also be made party in that litigation. So in that case he can make an application and court can exercise its power, because we have seen the provision of Order 1 Rule 10 that court is having power to add any person as a party to that litigation, and court can exercise such power at any stage of the proceeding. So object of Order 1 Rule 10 is to save such honest and bona fide claimant from being non-suited. And this power to strike out or add the parties can be exercised by the court at any stage of the proceeding. The Supreme Court further observed that this power of the court to add a party to the proceeding cannot depend solely on the question whether he has any interest in the suit property. So what is the criteria for the exercise of this power for the purpose of adding any person in the proceeding? This is not the sole criteria, whether he has any interest in the suit property. What should be the criteria? The question is whether the right of such person may be affected, adversely affected, if he is not added as a party. So, what is the main consideration? Whether the right of such person may be affected if he is not added as a party to that litigation. So, this is the test. Then, Supreme Court further observed that the transferee pendent lit means pending the litigation. Transferee means purchaser. For example, purchaser, in our case, Mr. Amit Kumar. Transferee pendent lit can be added as a proper party if his interest in the subject matter of the suit is a substantial and not just peripheral. That means the interest of that transferring suit property should be very strong interest. It should be the substantial interest. A transferee, to the extent he has acquired interest from the defendant, to that extent he is visually interested in that litigation also. So up to that extent up to which he has acquired an interest in that suit property from the defendant, he is visually interested up to that extent in that litigation with respect to that property. And especially when the transfer is of the entire interest, whole interest of that existing defendant, then consequently that defendant having no more interest in the suit property, it may be possible that he will not defend that suit proceeding. That means when that existing defendant transfer his whole interest to that third party, then in that case, because he is not having any more interest in that suit property, he will not even defend the suit. And if he will not defend the suit, and if the third party is not added as a defendant in the suit, and if he is not allowed to take a defense in that matter, then it will cause huge loss to that third party. Therefore, ultimately, finally, Supreme Court held that because the High Court has committed an error by rejecting the application of miscellaneous application for substitution of that applicant Amit Kumar as a respondent in that pending appeal before the High Court. So High Court has committed an error. Therefore, this division bench of the Supreme Court said that we have no hesitation in setting aside that order passed by the High Court, and Supreme Court says that we permit the appellant to come on record by a substitution that is in the place of and instead of that original respondent Srimati Kalyani. Therefore, Supreme Court observed that the High Court has proceeded with respect to that miscellaneous application on very wrong premises. What are the wrong premises? High Court has proceeded on wrong premises that the appellant had made an application for his addition as a party. So this is the wrong premises. High Court has proceeded on this wrong premises that appellant has made an application for addition of his party in the proceeding, but he has not made that application for his addition. But Supreme Court says that application was for the substitution in the place of original respondent, substitution instead of original respondent, because that original respondent who was the owner of that suit property had sold the suit property to the appellant, and therefore that original respondent had no more interest either in the suit property and therefore in this pending litigation before the High Court. So High Court has wrongly treated that application as application for the addition of the party, whereas Supreme Court said that application was not merely for the addition of the party, that application was for the substitution of the party in the place of original party. Therefore, this division bench of the Supreme Court said that, in our opinion, the presence of the appellant is absolutely necessary, because now that appellant Amit Kumar is the only person now who has got subsisting right title interest in the suit. Therefore, appellant Amit Kumar be added as a respondent in that pending appeal before the High Court, and appellant is at liberty to contest that matter on merit before the High Court. Accordingly, Supreme Court allowed this appeal preferred by Amit Kumar. That's I will stop here. So I have discussed this provision relating to Order 1 Rule 10, Order 22 Rule 10 and Section 52 of the Transfer of Property Act. Thank you.